Okay, so last week in the class, which I didn't have you for, I talked a bit about blogging, and I put that online, so I think you can go and look at that on the web rather than have you a week behind everyone, because I'm doing 3 instances of this module. So as far as I can, I want to have everyone doing roughly the same thing at the same time, because otherwise it'll wreck my head. I mean, probably be better for you too, but it would certainly be better for me. So you can go look at that online. By now you should have set up your blog and emailed me the URL of it. If you haven't done that, we'll be able to sort that out in the lab this week. And in the lab this week as well, I will also talk you through a little bit of the kinds of things I'm expecting you to do each week. So that's already posted on the blog if you want to go read it, but I'll talk you through that anyway in the lab. So by the end of this week, you'll have your entries in for this week, and you'll have the blog set up, and also in the lab we're going to look at customizing it and stuff. We're not done with blogging and stuff like that. This module is going to jump around a bit. So whereas say in COMP6023, your web development fundamentals module, you kind of had a beginning and a middle and an end. You know, there was the HTML and you could see the CSS and the JavaScript and stuff. Not unlike a kind of a 4 or 5 course meal, this module is going to hop about. It's going to be a bit more like that. It's going to have a bit of this, and then, you know, the next week we might do a bit of something else. So the order won't be especially important. So we'll be hopping about a bit. In the next few classes, we're going to think a little bit about intellectual property. So I'm going to explain some of the different kinds of intellectual property and some of the different kinds of terms and things that come with it, because sometimes there's a bit of confusion. And then when that's done, we'll do something completely different again. And I don't know what that is yet. It's that planned out. So by the time we're finished with intellectual property, I'll have sorted out what we're doing after that. I will also pin down very, very soon the assignment schedule. I have pretty much first part, second part. I'm just waiting to make a decision about the third part, and I'm waiting on something from Google to do with that. That's looking like it'll happen in groups, that you'll have some work to do in groups. So if you want to have a think about that already and who you'd like to work with in your group, maybe that's something you could be doing, just negotiating who you want to work with and who you would prefer not to work with. I imagine you all know each other at this stage, so I'll let you form your own groups rather than me randomly assign them. And then if someone is groupless, we'll see. Okay? It may happen that that doesn't pan out, so I won't tell you about it until I know it's all going to work out. But if it does pan out, you'll need to be in groups, so you don't want to waste time thinking about that. And the groups, I think, would be 3 or 4 people. No. So in this class and the next few classes, we're going to think about intellectual property, sometimes called IP. And we're going to look at different kinds. But the first kind we're going to look at, and the kind we're most familiar with, that we deal with from day to day, is copyright. And copyright is a scheme set in place, typically policed by governments. But it's perhaps better to think of it as a contract between authors and society. You know, they give us something and we give them something in exchange. So copyright gives protection to an author that prevents other people from making copies of their works without their permission. So you can't take the text of one of the Harry Potter books and print it out and, you know, go selling it on Patrick Street. The author of that work has rights that prevent you from making copies without her permission. Now, if she gives you her permission, yip-de-doo. She's probably not going to give it to you because, you know, she can make money, but she may choose to do that. For copyright protection to apply to a work, there are a number of criteria. So the work must be original. Now, the threshold for original can be quite low. But it needs to be a new work. It needs to be, not a copy of something else. What's the point of that? But when we say original, we just mean it's a new work. Like, some people might argue that, the first few Harry Potter books, or certainly the first one, wasn't that original, But I mean, we don't mean originality in the sense of like, wow, fab, that's an original idea. We mean just new, hasn't been written before. So you can't take something that was written 100 years ago. If you were to publish a book under your name, for example, and we actually discovered that it was in fact written 200 years ago by someone else, and we found that book in the library somewhere, well then you wouldn't have any rights there. It wasn't original. Well, first of all, you didn't write it either. But if somehow you could coincidentally write a book that had been written word for word 200 years ago and was already in existence, it wouldn't apply. So it must be a new work. It must be non-functional. That just prevents you copyrighting things that aren't really creative works. So the shopping list I bring to Tesco, okay, that's original. And okay, I wrote it. But is it really is it art? No. It's not a creative work. So it probably wouldn't apply. So I probably couldn't copyright I probably couldn't claim copyright on my shopping list from Tesco. Again, though, the threshold would actually be quite low. You can copyright, you can protect many things with copyright protection that you mightn't think you would. Like the contents of a database is copyrightable. Now you might think, the person that owns that database, all they did was take inputs from people and shovel them in and normalize the database, whatever. Like, that's not really a creative work. But databases can be copyrighted, although you might get someone challenging that. Certainly if someone ran off with the CIT database, the student database, aside from the data protection issues, CIT could probably claim that no, that was CIT's intellectual property and you can't just make a copy of it. But we'll see some interesting cases, because some of the challenges facing copyright law, the fact that it's old law and old principles hitting up against new technologies and new ways of doing things. You see how sometimes there's a bit of conflict there. A very important thing about copyright is that it must be fixed in a tangible medium. So if you write a song, it doesn't get any protection until you write it down, put it in some tangible form. The fact that it's in your head is no good. Now, the definition of tangible, again, is quite flexible, and the threshold can be quite low. I mean, if you wrote it on a leaf, somewhere, and, in 2 years' time, someone else is singing your song, you're claiming, no, I wrote that, and, I wrote it on a leaf and gave it to the wind, as a gift or something. I mean, the courts might say, well, that wasn't tangible enough. But, if you recorded it, if you made a recording on your phone, that would be considered, intangible medium. I mean, there was some dispute over what was tangible and what was not. Was a magnetic tape, could be computer magnetic tape. Was that tangible? I think there was even a case about, do you know those kind of, I saw it in a cartoon last night. In the West they had these you had these pianos that play themselves, kind of a big roll of paper, that looked like a kitchen roll. But I guess it was, thicker paper. I think there was a court case involving that, and people were arguing, well, that's not a tangible medium because, humans can't read it. It's only machine readable. Was that tangible or not? I'm not sure how that case went, but most courts now will accept that, the tangible medium doesn't have to be human readable, provided there's some mechanism from translating it into a human readable form, say. So someone could argue, well, my database is on a disk, But I could print it out and you could read it. So I could give it physical, human readable form. You wonder if something is in the cloud. If you record something, if you record your song to Dropbox. Of course, actually that's a bad example because it would be a copy on your hard disk. But let's say you put it in the cloud somewhere. I mean, I wonder will a court someday decide that, that the cloud isn't a tangible medium. But I imagine the law will adapt and that would be fine too. But I'm saying you must give it physical form. That it's in your head isn't enough. So you can't copyright an idea. You sometimes hear students say, oh, I copyrighted that idea, man. You can't do that. You don't copyright ideas. You copyright artistic expression. So you copyright the words that give form to the idea. Now, if someone uses words very similar to yours, I mean, if you write a movie script and someone else writes the same script but with different words, you may have some issue there. You could say, well, that's kind of a derivative work and they couldn't have done that. But the idea itself is not copyrightable. So some distinctions there. This is a definition of copyright from the World Intellectual Property Organization. So that's an industry body. It's I was going to say if you were file sharing, these are the people that would come knocking at your door, but no. If you're a government, if you're a country that persistently lets servers in your country be used for file sharing, then maybe they'd come knocking on the government's door, at a higher level than that. And this is an organization set up to one of the things it's done is harmonize laws or help harmonize laws across different jurisdictions and things, stuff like that. But this is a good definition of the purpose of copyright. And I'm saying whatever about the legal definition, and that might vary from state to state, there's certainly agreement on the idea behind copyright, and that it's an exchange between society and creators of artistic works. And so the purpose is to encourage a dynamic culture while returning value to creators so that they can lead a dignified economic existence and to provide widespread, affordable access to content for the public. So I would say now that this paragraph here went through many, many revisions to try and keep, everyone happy. So you notice it's not saying so that creators can get loads of money, lead a dignified economic existence. I mean, how much money do you need for a dignified economic existence? Probably slightly less than what Bono has, but he's entitled to his money too. And also to provide widespread, affordable access to content for the public. So the idea is really an exchange. You want artists to make money so that they can keep doing what they do. So let's imagine for a moment that I am Ireland's greatest rapper. And I could be, you don't know what I do in my spare time. It is certainly possible. It would be nice if I could quit this lecturing lark and concentrate on my music. But for me to do that, I have a mortgage, I could be an artist, but I don't want to be a starving artist. I don't want to be on the street living in one of the prefabs over there when I could be at home. And I'd like to go on holidays, do things like that. So it'd be nice if I could quit the day job and do all my music. And so copyright is a mechanism whereby, because I have control over who can make the copies, I can maybe make some money from that. And so the deal is like, society respects my copyright, I get some money, and so I can keep doing that. Now, as you know, these days, if you're a musician, there are some issues with getting the money. It was easier before. But now with the different technologies, it can be hard. Similarly, if you take J.K. Rowling, I mean, she, plenty of money now, obviously, and good luck to her. She probably couldn't have written all of the books if she didn't get some money from the first one. Do you know, she published the first Harry Potter book and people said, you know, that's a lovely book. Well done. Thanks very much. You're fabulous. But she didn't get any money. Well, like, it's back to her day job for her, or back looking for a day job. You know? So the fact that she was able to make some money from her artistic endeavors meant that she was allowed to keep doing it. And so that's kind of the deal we make. Now, you know, you might argue about the quality of some kinds of artistic endeavors, and I won't name names. You know, people make loads of money from crap, but that's quite subjective. But I think everybody has at home, in some shape or form, 3 or 4 albums, as I'd call them. I don't know what you would call them. But like 3 or 4 albums that if someone said to you, look, we're going to take these away from you forever unless you say, give me €10. There's quite a few things you have. You said, you know what, I'd pay the €10. That's worth €10 to me. Or 15. I mean, there was a time now they wanted €25 for a CD, which I thought was really pushing the boat out. But, you know, everybody has something at home that they think is maybe worth the money, you know. And the idea is that maybe artists should get some of that. Some artists have gone straight to the public. So you had people like Radiohead publishing music online and just saying to people, pay what you think it's worth. Now that's fine once you've made your money, you know. As Ireland's greatest rapper, I couldn't afford to do that because it might not happen that I would get enough money for my mortgage. But when you're already rolling in money, you can do those kind of things. So get the idea. So whatever about the legal principles and the legal definitions, there is this exchange here. And you might argue, well, you know, that person has enough money already. But the principle is sound, I think, that if we want people to make music instead of being lecturers, or if we want people to write books instead of, you know, being accountants, we need some mechanism for them to make a few bob at it. You know? And that's kind of the principle of copyright and the contract between society and the artist or the author. You really get the idea? So that's kind of the motivation for copyright. And even, of course, we all agree with that, and then we all go and copy stuff anyway. But so copyright gives the copyright holders then some exclusive rights. So the obvious one is the right to copyright. But also the right to produce derivative works. So, I mean, you couldn't make the Harry Potter movies. I mean, one is a book, one's a movie. You know, you haven't copied anything, but it's a derivative work. So she had to get paid for that too. The right to distribute copies. So even if you don't make them, you can't distribute them either. If it's not yours, you know, you need the permission. So, you could contrive some example where copies were made legitimately but not distributed legitimately, and the author says, no, you can't do that. Perform works in public, some musicals, plays, whatever. So when you go to a play, I mean, the person that wrote the play is supposed to get some money. And that's how it works. Or even to display the works in public, you know, photographs, things like that. There's a very interesting concept in the US which doesn't apply in Ireland. And that's one of the issues, of course, with copyright, is that the law is very different from place to place. And that was fine, really, when, you know, you printed a book in Ireland, you were selling it in Ireland. But when you go online, things start to get a bit more complicated. But that's something we'll look at. But this fair use concept exists in the US, and it's a very good scheme, I think, that, or a very good principle that allows stuff to be copied in certain circumstances. So it's saying every author or publisher may make limited use of another person's copyrighted work for purposes such as criticism, comment, reporting, teaching, scholarship, or research. So you could imagine, for example, if I wanted to talk about the writing style in the Harry Potter books, for me to do that competently, for it to make sense, I might need to reproduce, a paragraph or two and say, you can see here now that we have blah, 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 blah. Having read none of them, I can't give you an example, but you could see how that would work. Also, and the criticism one and the comment one has kind of been stretched to its limits, I think, in the US. That if you want to criticize something, well, you may have to quote it. So if I want to say, the second Harry Potter book is really crappy, then I may need to reproduce sections of it to back up my argument. Or if I want to comment on it, I may have to do that. Included in this is the concept of parody. And I'll give you an example of that in a second. But also then there's exemptions for teaching. So if we were going to have a class on the writing style in Harry Potter, I might need to make some photocopies of 1 or 2 pages. Now, if I photocopied the whole book, well, that's maybe stretching it too far. And so there are limits, and we look at those limits. But first I want to give you an example of something that was used. So, do you remember the movie Downfall with Hitler in the bunker? I remember there was sort of almost a subgenre of YouTube video where you put new subtitles on it. So there was like the Michael O'Leary one giving out about Aer Lingus or something. There was Bertie Ahern giving out about his cabinet and things like that. Well, the people that made the movie weren't that happy. And you could see, why they might not have been. I think Germans weren't happy with the trivialization of the Third Reich, but that's kind of a separate issue. But the person that made that movie, that spent the money to get that movie made, those people weren't happy with that. And the people that made the videos were claiming, well, this is a parody. This falls under the concept of fair use. And so, let's say there was some Britney Spears song, right, which you thought was particularly thick, and you recorded a sort of a funny, stupid version to the same tune, for example, right? Well, the person that wrote that song might say, well, the melody to that song, I have the copyright on that. But you could argue, but no, I'm making comment on that song. I'm criticizing that song through parody. And you might claim some protection in terms of fair use there. And so sometimes you actually see at the start of a video someone going out of their way to use the word parody. It might be sort of a little text at the start. This video is a parody of whatever, whatever, whatever. It's because they're claiming protection under this fair use. So if you want to say, like, this is a really stupid song and sing along to the tune of that song, you could argue that's a fair use. And this only applies in the US. You wouldn't get very far with fair use in Ireland, I think. Now, so the precise definition then of what's fair use and what's not isn't set out. But these are the issues that would be considered. So like the purpose and the character of the use. So what are you doing? Are you trying to make money off of this, for starters? That would, that would make a difference. If you recorded, if you recorded your, stupid Britney Spears song, and made lots of money, there might be some issue there. There's also the nature of the work. Then, what is it you're doing? It's an important one. So the amount or substantialness of the portion used. So, if in my discussion of the writing style in the Harry Potter books, I photocopy 2 pages and give them to you, or I photocopy the whole book, that's a different kettle of fish. 2 pages out of a book is one thing, the whole book is another. And then remember, if the purpose of copyright is to make sure that the author gets some money, then is the use of the copyrighted work going to affect the market for that? So if you take the downfall example, I mean, I don't think anyone who saw that YouTube video would say, well, you know, I saw that 2-minute YouTube video, I've seen the movie, I'm not going to bother go see the movie. It's not like that work was affecting the, you know, the market for the whole movie. So there are things like that that need to be considered. I think there's also a moral right, which, you know, I think if you create a work, okay, you should have control over it in terms of, you know, making money from it. But I think you should also have control over it in terms of what happens to it. You know, that people shouldn't be able to just, you know, take it. And there's a very good example in the US of a case that people took, and I'll put it on. I put a link on the blog already. But it was 2 guys who got married, had their wedding photos online, and an anti-gay group used that picture in their publicity campaign. And these guys were saying, well, you know, there are wedding pictures, okay, they were on the web and stuff, but, you know, we should have some say as to what happens with them. And I think in the end, the anti-gay group used this fair use concept that, well, they were arguing that it was a commentary, you know. But somehow I find that unsatisfactory. Do you know what I mean? It seems to me that your wedding pictures are sort of, you know, not private, but somehow that someone could take some of your work and use it for an unintended purposes seems to me to be a bit of a stretch. But that goes into sort of the moral right of artists rather than, you know, the legal and copyright ones. So how do you get copyright? Well, it's automatic. So once you give the work tangible form, once you write it down, it's protected. It has copyright protection. And then that copyright lasts for 70 years after the author's death. Now, this is one of the issues that people have with copyright. 70 years is a long time. I mean, okay. No. So, I mean, while returning value to creators so that they can live a dignified economic existence. I mean, 70 years after I'm dead, you know, there was an argument that, well, while you're alive, you should be making some money from your work. And then there was the argument, well, you know, your kids should make some money from it after you're gone. But at this stage, we're up to, I think, grandkids. You know, 70 years is a long time. So it was 50 years, was extended to 70 years. It was 50 years in some places. At times in history, it's been much shorter. At some times, it was only maybe even 30 years, you know, after it was created even. So it's varied a lot. We've kind of pushed it out more and more and more. I wonder, will my rap music still have the same meaning 70 years after I'm dead? You know, will there be much money to be made from it? I don't know. But some people argue that 70 years is just too long. Okay? Of course, the problem then with copyright is that it can be difficult to enforce. When there were, you know, 20 printing presses in town, it was easy really for, you know, the king's men to go around and make sure that they weren't printing anything they weren't authorized to print. But, as I'm sure you're all aware, it's very easy to copy a whole CD, for example. It takes a couple of seconds, really. Then you have a copy and you can give that to someone else and they can have a copy. So the ease with which music and movies in particular can be copied and then can be distributed using networks has posed some challenges for copyright enforcement. And then there are cross-border complications as well. I mean, if you're in France and I'm in Ireland and you give me an album or a movie, like who are we going to call? French police, the Irish police? Where does it all, where does all this happen? I mean, we don't really have a cyber police policing the cloud. So that poses problems as well. And of course, then you just have, you have entire rogue countries who are just quite happy to host anything and do whatever. So different government agencies and intergovernment agencies have been working on, trying to iron these things out. But it's certainly complex. If you take peer-to-peer networks like Napster, for example, which is a bit before your time, but that didn't actually copy any music. It's just if you had something you wanted to share and you were looking for that same thing, well, Napster, introduced you to each other, and then you copied it from him. Napster never had it. So when it came then to Napster being hammered for copyright infringement, the people behind Napster, their argument was, but sure, what did we copy? We never had a copy in our possession in the first place, and we never made any copies, so how can we be infringing copyright? And that was certainly a reasonable argument. So laws have been updated and changed to make facilitating copying a problem too. So even if you don't do the copying yourself, but you allow other people, or you give people a form in which to do it, then that poses a problem. The question then is, do you throw all ISPs in jail? I mean, if you're on Chorus and you're on Chorus and you share with him, does someone from Chorus go to jail then? There are these complex issues. The Digital Millennium Copyright Act was an important piece of legislation in the US because some people argue really that it was written by Hollywood, and it doesn't just make the copying of stuff illegal, which was always illegal under copyright law. It criminalizes the production and dissemination of technology, devices, or services to circumvent digital rights management. So, for example, DVDs are encrypted. Now, I don't actually own a DVD player anymore. So when I buy a DVD, which I still do, I have to put it into the computer and rip it so I can watch it on my iPad or watch it on my TV. So, in doing so, I guess I've broken the law. But what the Digital Millennium Copyright Act does is it makes the person who wrote the software that I used to rip the DVD a criminal. So if you write software to rip DVDs, you could be, thrown in jail, in theory. Not just in theory, in practice people have been put in jail. So it criminalizes the act of circumventing access controls, whether or not there's actual infringement of copyright. So if you write certain kinds of code, you could be breaking the law by virtue of the fact that other people might do things with it. And so that proved very problematic. And there were some very interesting cases where people claimed that someone had broken the law and went to court, and I'll talk about one of them. An issue for academics was that even discussing or publishing or doing research on some kinds of encryption could land you in jail. So if I did some research, for example, on the encryption algorithm used to encrypt DVDs, and I pointed out that, you know, it's flawed in this place and this place and this place and blah, 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 blah. In publishing that, I might end up in jail. So the Digital Millennium Copyright Act went much, much further than many people are comfortable with. I think the most famous case, and the one that highlighted the problems the most, was one that Lexmark, printer manufacturer, took against a generic cartridge manufacturer. As you know, printer companies, they give you the printer pretty much for free. Like, I mean, they don't make money on the printers. They make the money on the ink that you have to buy for your printer. And so, as you know, you can buy the, you know, posh HP ink, or you can get the cheap and cheerful ink for maybe half the price. And obviously, HP would argue, probably quite reasonably, that the quality of the ink you're getting, you know, from the third party isn't as good. But what this one company, and many others have done it too, but what this one company, Lexmark, did was they put a chip on their ink cartridges and a chip in the printer. And when you put your new ink cartridge in, you know, the printer and the cartridge spoke to each other, and the printer asked, you know, are you a genuine Lexmark printer cartridge? And the thing would say, yeah, I am, and prove it, and blah, 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 blah. So they had this like handshake, and only when that process was complete would the printer actually print. So if you went down the road and bought a cheap and cheerful cartridge and put it in, the printer wouldn't work. Or if the printer ran out of ink, the cartridge ran out of ink, the cartridge would remember it ran out of ink. So if you filled it up again, it wouldn't work. So what one company did, what the generic printer ink company did, and I'm wary of using the word, but I suppose what we'd call it, like they hacked it. It's probably the best description that we might call it. So they basically looked at the codes so that they could make printer cartridges that would work in those printers. And so the original company then was, well, hang on a minute now. The Digital Millennium Copyright Act says you can't be going around circumventing access control. That's not acceptable. That's breaking the law. And so this went to court and went to court. And eventually Lexmark lost. Okay? But you could see how maybe the reach of the act was too far. You know, most people would think that it's perfectly reasonable for someone to be able to want to make printer cartridges. And so that's an interesting one to read about. I have links to that on the blog. So let's just see what's coming up. The printer cartridge case there. So in the next class, we'll just briefly look at maybe the idea of making new works out of old. So for your blog this week, you're just going to be talking about what we did in weeks 1 and week 2. You can maybe summarize briefly, and maybe talk about this more in class again in the labs. But I want you to just think about sort of privacy and how private a person you are, and what you think would be appropriate for you to put on your blog, and what would not be. So think about how private you are. Some people are more private than others. It's just the way it is. Then next week I'll give you some maybe copyright things to think about that maybe you could write about in your blog. Okay, so week by week you'll have the minimum requirements for your blog will be to say what we did in class. But then for more marks you might want to sort of reflect on it a bit and add to that. And there's details of that on my blog, colinmcit.blogspot.com. So you can go check there. We'll discuss it anyway in the labs. And just make sure that by the end of this week you've set up your blog and that I have the URL for it. Okay, any questions on any of that? Okay, great stuff.